Good morning. This is the time set for discharge hearings. If you are a creditor or an attorney representing either a debtor or a creditor, please identify yourself at the time I call the case for which you are appearing. Today we're going to talk about your discharge and your reaffirmation agreements. Before I talk with you individually, I want to give you some information about your bankruptcy discharge and reaffirmation agreements generally. You will receive your bankruptcy discharge 21 days from today. The bankruptcy discharge relieves you from paying most, if not all, of your pre-bankruptcy debts. Some debts, however, such as child and spousal support, for example, are accepted from your discharge. People who buy things on credit sometimes promise that the lender can take back the property purchased or some other property if that debt is not paid. That property is called collateral. Although the bankruptcy discharge ordinarily relieves you from paying the debt, it will not prevent the lender from repossessing the collateral if you miss payments or otherwise default in your contract. A reaffirmation agreement is an agreement to pay a debt notwithstanding the fact that you've discharged the debt in bankruptcy. If I approve the reaffirmation agreement, that debt will not be discharged. If you miss payments or otherwise default on the reaffirmation agreement, the creditor has all the rights provided by law to collect the full amount of the reaffirmed debt. So not only will the creditor have the right to repossess the collateral, but if the property does not sell for enough to pay the debt in full, you may be liable personally for the unpaid balance. So let's talk about that for a minute. If you have a car that's worth $10,000 and you owe $10,000 on it, you're thinking, I'm okay. But what happens if you don't pay? The creditor can repossess the car, and then they've got repossession costs, then they have storage costs, they have selling costs, they have the costs that it takes to make the car saleable, and they're not going to sell it on Craigslist or through the newspaper or whatever. They're going to take it to an auction. So that car that you think is worth $10,000, they're never going to get $10,000 net out of it. And so if you owe 10 and they get, let's say, 7, and that's being generous, let's say they get 7, then you're still going to owe them $3,000. And if I approve your reaffirmation agreement, they can sue you for that $3,000. So it's a pretty serious thing when you're entering into a reaffirmation agreement. So by reaffirming that debt, and if I approve it, you lose the benefit of the bankruptcy as to that debt. And that's why I take these things very seriously and I talk with each of you individually. In order for me to approve a reaffirmation agreement, I must find that it does not impose an undue hardship on you or your dependents and that it is in your best interests. There can be many reasons why reaffirming a debt is not in your best interest. For example, if you cannot afford to pay the reaffirmed debt, it will not be in your best interest to reaffirm that debt. Nor is it generally in your best interest to reaffirm an unsecured debt unless a creditor has objected to the dischargeability of that particular debt. You need to know that under no law, either bankruptcy or non-bankruptcy, are you required to sign a reaffirmation agreement. You also need to know that those reaffirmation agreements you've already signed are not final or binding unless and until I approve them. If you do not want to reaffirm a debt, tell me today and I will not approve the reaffirmation agreement. And I don't approve it, and we don't have to tell the creditor that you said to me, I don't want you to approve the reaffirmation agreement, Judge. You also have a short time to cancel the reaffirmation agreement if after today's hearing you decide you do not want to reaffirm. To cancel, you must send the creditor involved a letter stating that you are canceling the reaffirmation agreement. That letter should have your name and bankruptcy case number on it and should indicate that you've mailed a copy of the letter to the court. You may cancel a reaffirmation agreement only up until your discharge is effective in 3 weeks or within 60 days after the date the reaffirmation agreement was filed with the court, whichever deadline is later. And for most of you, if not all of you, that later deadline is going to be 3 weeks from today. You can always voluntarily choose to pay any debt that's discharged in bankruptcy, even if you do not reaffirm the debt. So some of you may owe a doctor or a dentist or a relative and you want to pay them back. There's no law that says you can't pay them back. Feel free. But you're not obligated to pay them back. That's the difference. To summarize some important points then. 1, if you reaffirm a debt, you lose the benefit of bankruptcy as to that debt. 2, you do not have to reaffirm a debt if you do not want to. 3, if you don't want to reaffirm a debt, tell me and I will enter an order that cancels the agreement. 4, if there's no benefit to you, I won't approve the agreement. And 5, if I do not approve the agreement is canceled, but you still may voluntarily pay the debt. I will now take the cases one at a time. If you have any questions about your discharge or reaffirmation agreements, I will try to answer them. However, I cannot give legal advice about your bankruptcy. After we've discussed your case, I will tell you whether I will approve your reaffirmation agreements. If any of you know now that you do not want a reaffirmation agreement approved, you may leave and I won't approve your reaffirmation agreements.